Okay, we'll go ahead and get started. Good afternoon, everyone. Thank you for joining us today to talk more about the SH46 road project. This is a community webinar that we are going over a few things to just keep you informed and see how we can help you out. My name is Brittany Folgate, and I'm the marketing manager here at Braun Gresham, and I will be moderating today's presentation with attorney Patrick Resnick. Today's presentation is around 45 minutes in length with Patrick, and he will go over the project details, current status of the project, next steps, and what to do if you are facing condemnation. We would like to address questions at any time throughout the presentation, and so if you have questions, you can click the raise hand button that is located in your toolbar, and I will unmute you and you can speak and ask your question. If you don't choose to speak, you can type any questions into the Q&A feature that's located on your toolbar. We will also be following up today with this webinar recording to you via email so that you can have it and ask us additional questions after the fact and consult Patrick and his team with the consultation and see how we can help you out further with this project. At this point, I'll let Patrick go ahead and get started.
Well, thank you, Brittany, and good afternoon, everyone. We certainly appreciate your attendance to this program. What we're trying to do is get information out there that is relevant for landowners during the condemnation process, and in particular, this SH46. But I'll remind you that anything that we discuss today, other than the details of SH46, are general principles that apply to condemnation proceedings with governmental agencies or other entities that have eminent domain authority. So you can apply that to whether it's a pipeline coming through, a transmission line coming through, a water or wastewater line coming through, a city road project, a county road project, or TxDOT project. All these legal principles that we're going to talk about today still apply, even though we're going to focus on SH46. There's a lot happening around the state of Texas. Braun Gresham and represents landowners around the state. In particular, I represent only landowners in these condemnation proceedings when their land is being taken. And I use the word taken, and you're going to hear that throughout this presentation, because these governmental authorities or private authorities with eminent domain authority are taking your land. That's not a sale. A lot of times they're going to send you like sales documents or documents that pretend that it's a sale. It is not. It is a taking. So it's not a private sale. It's not an at-arm's negotiation where you're selling your property at will. This is your land being taken either for a easement, which is a pipeline or water line of any other side of wastewater line or transmission line. That's going to be an easement, which means you still own the property, but the third parties have right to build infrastructure and maintain infrastructure and be on your property. SH46, for example, is a TxDOT project. They're going to be expanding SH46 from I-35 to I-10. We're going to get into those details. And they're going to be taking that land in fee, meaning that TxDOT will actually own that land. So it will be taken from you and you will no longer have to pay taxes on it. But when a easement comes through, it's still your land and you're still going to have to pay taxes on that property. What we're trying to do is give you enough information so that you feel a little bit more empowered. But as Brittany will talk about at the end as well, we do provide free consultations to provide you more information and one-on-one specifics about the impact that this project or other projects may have on your property. The idea of eminent domain is a complicated one, and it has a lot of an emotional, oftentimes, impact to landowners because they don't feel like they have control and they don't. They don't have control over the process. The process is very detailed in the way it is handled that we'll talk about. But overall, I want to talk a little bit about 46, the project details, where this right to eminent domain to condemn people's private land comes from in the U.S. state constitution and state property code. What are your rights? I'm going to give you a real life example of a case study on 281 north of San Antonio, and then essentially what you can expect during the process. So let's talk about this particular project, the details of the project as we know it today, and what the general timeline is. This project location, as you may know, if you've gone to some of the presentations by TxDOT or looked at their website on some information, is definitely a much needed expansion of SH46 between I-10 and Seguin area, I-35 in the Bronzeville area, and the corridors connecting and interconnecting SH46 with I-35. It's going to be impacted with Comal as Comal County ends just east of the Bronzeville, and then Guadalupe County continues all the way to Seguin. We'll break this project into the counties so that you have a little bit better perspective of what's happening on I-35, 46 corridor, and Comal versus Guadalupe County. And you can see here is the county line. So most of this project is going to be happening in Guadalupe County. This is a schematic from TxDOT that shows what the existing project is right now in its current state. And this is a generalization, but what's important about this is if you drive on 46 between I-35 and I-10 right now, it's going to be a 2-lane on each side, both going generally eastbound and then westbound, and then a center turn lane. And then you have about 18 feet of existing utility corridors on each side of that. So as a generalization, the existing right-of-way that we have to use now or that TxDOT owns is 120 feet. The impact of that is I want to show you how much that's going to be expanded both in Comal County and Guadalupe County with the next couple of slides. So this is what we have now in general. This project is definitely needed from a safety standpoint, improving, accessibility, what we call mobility, reduce the kind of congestion, especially during peak time periods. And I think if you've driven on 46 and you get frustrated with it's just dangerous, people turning across traffic on both ends. There's not very good controlled intersections. There have been deaths along this corridor, some very serious automobile collisions, and so we all know it's needed. They are definitely having funding for this project, so it's going to move forward. If you look at the last bullet, 2024 is what is expected to have the final design, because what we have right now are preliminary designs subject to change. But as we move forward in 2024, that final design will happen. At some point in time, there'll be a public hearing. A public hearing is different than a public meeting or these workshops that TxDOT may have provided to give you more information and to get public input. The public hearing is not for an informal question and answer. It's actually a recorded hearing at some given location. The public can show up, and TxDOT presents this project, but it's not time for a Q&A. You're not having questions and answers. It is a very formal hearing presentation. And after the meeting or after the hearing, there may be ability to ask some questions, or maybe before, but the hearing itself is a very formal process. There's also what's called an environmental impact statement. EIS is what it's often called. They have to get, when I say they, that's TxDOT, has to get environmental clearance in order to go ahead and build this project. from an environmental standpoint, whether it's endangered species or whether it's potential impact to water sources, things like that. And all of that is expected to happen in 2024, this year, which means as we're moving into April next week, the acquisition or the condemnation process will most likely start. It's very difficult to establish this date, but based on my experiences and knowing a lot about this particular project, I could see request to survey, and we're going to talk a little bit more about the request to survey towards the end of the year or the first of next year. Let's talk about Comal County and Guadalupe County just a little bit more. This is from TxDOT's website, and it talks about what's going to happen on I-35, 46, expansion interchange. But essentially, what's going to happen from I-35 all the way to through Comal County is going to be an elevated ramp. And so there will be an overpass essentially in that particular area. If you're going northbound on I-35, you'll be able to get to SH-46 going in an easterly direction. If you're coming on 46 from Seguin, that area, you start getting into I-35 going westbound, there'll be a flyover to get to the southbound part of I-35. That is all that's planned right now, or those two flyovers. Of course, there's other flyovers that could happen in the future. If you've driven on I-35, you notice TxDOT is always adding another flyover, but it may take another several years before those additional flyovers added. But that's what's in the plans right now on the I-35 46 exchange. And of course, the Business 35 is on the west of I-35, and that overpass is going to continue to the westerly portion on I-46 past I-35. This is essentially what the general schematic is. And if you notice on the bottom, as we talked about, 120 feet is the general width of what the existing right-of-way. And we would say right-of-way, that's what TxDOT owns and has the right to use because it's their property. The proposed additional right-of-way is anywhere between 145 feet total and 185 feet. 152 is what they're saying is essentially an average. That is a tremendous amount of expansion from 120 feet. And it can happen on either side of 46 as the design is completed. A lot of times my clients ask me, well, why don't they just do it all on one side or the other? Or why are they taking it all on me? Why don't they take a little bit on both sides? That is completely up to TxDOT and their engineers from their design perspective and designing this project. It's not necessarily they're trying to be unfair or more fair to any particular landowner. It's just that's what the design happens to be, and the impact is to the affected landowners on one side or both sides of the existing 46. So you could have another, 32 plus feet or another 60 plus feet taken from your property. And you will lose, if you have frontage, you will lose that frontage to TxDOT. Of course, you'll have new frontage if your property is large enough, but in this area where some of the overpasses are happening, especially in Guadalupe County, there are people who are going to be displaced. They're going to lose their home. They're going to lose their business. That's just what happens with these expansions because it's pretty extensive, especially when you get to some of the overpasses in Guadalupe County. Right now, there's about 5 particular overpasses. I have clients on the Mary Boulevard and Sanger Hall Road, which those two roads do not connect evenly when you get to 46. So TxDOT's plan is to connect those two roads on both sides of 46 and have a overpass there. It's going to take out 2 of my clients' homes. They're going to have to get, paid for all the damages associated with that. And then they're going to have to relocate because they're going to lose their homes. There's also several other projects that if you keep going down to Seguin, and these are in order going east to Seguin, and then even there's a planned Pecan Parkway, which is most likely going to be a county project, but TxDOT has that in the plans to put a overpass in that area as you get closer to Seguin. So this is a very extensive project. It's going to take a lot of land. It's going to impact a lot of businesses and a lot of homes, all for the benefit of the public. And that's what eminent domain authority for TxDOT is, so they can condemn for the benefit of the public. And part of the whole process is, in my perspective, in representing my clients, is to make sure they are treated as fairly as possible. So this is going into Guadalupe County, as you can see right now, 120 feet to potentially 260 feet. So another 140 feet, but it could vary to up to 400 feet at the intersections and ramp locations. So there's going to be a significant amount of land that's going to be taken for these intersection overpass points along 46, and then additional right of way. There's going to have to be some transmission lines that are going to have to be relocated. So that's going to impact LCRA and some of the transmission lines they have, which are different than distribution lines. Distribution lines serve the residents or the business. These transmission lines are just that, to transmit electricity into the full grid of the state of Texas. And LCRA has some significant structures and infrastructure in that area, as well as GVRA and some water lines and all sorts of infrastructure that is going to have to be relocated. It may be relocated within the TxDOT's new right of way. It could be outside. So there are some landowners who may actually have more land taken because LCRA is going to have to move their transmission lines, or GVRA is going to have to move their water lines. So it's a very complicated process, and we're not going to know the details of those until after TxDOT has its final design. If there's any questions, Brittany, please let me know, and we can address those as we're moving through this presentation. I want to move into our second phase, is basically a little bit of understanding of this right to eminent domain. Eminent domain is the authority to condemn. Condemnation is actually the process of utilizing that authority in order to take landowners' private property for a public purpose. It comes from the U.S. Constitution, Texas Constitution, and Chapter 21 of the Texas Property Code. U.S. Constitution, the Fifth Amendment, which is actually a big issue right now before the U.S. Supreme Court on whether a landowner can sue TxDOT for taking their land and not compensating them if there is a way to go directly to federal court rather than having to go through the state process. So that's an interesting situation that is happening right now. And I have blogged about that. We'll continue to blog about that as that case moves forward through the court systems at the federal level. Like I say, right now it's before the U.S. Supreme Court. The Texas Constitution also addresses this. While the Fifth Amendment says it needs to compensate citizens when their private property is being taken for public use, Texas Constitution actually puts in the word adequate compensation. That's where the big dispute is most of the time, is what is adequate compensation. In my opinion, I want to make sure my clients get truly adequate compensation, but sometimes the condemning authority doesn't see it from our perspective that they need more because of the taking, and that, of course, they would prefer to pay as less as they could. And TxDOT is coming from taxpayers' money, and they will emphasize that at some of these hearings, that, listen, this is taxpayers' money that we're having to spend as compared to a pipeline company that is actually money for the profit of the pipeline company to their shareholders, even though they still have eminent domain authority. Then Chapter 21 of the Texas Property Code just describes the rules for the condemnation process. The rules can get very frustrating to the landowners, but they're very specific in what the condemning authority has to do. And I'll talk a little bit more about those particulars when your property is being taken. Now, let's move into, well, what are my rights? Do I have the ability to control this process at all? And the answer is you have very limited control, but you do have rights that needs to be exercised as far as the timeline is concerned, the information that you should receive, and how you handle what is adequate compensation for you in your particular situation. Now, every property owner has a different situation. While I'll often represent groups of landowners who are neighbors or contiguous properties, every property's impact is a little bit different. And your rights are to receive that adequate compensation under the Texas Constitution. This is some technical aspects that I just want you to come home with understanding, and that is the taking. And I mentioned that at the beginning that your property is being taken. It's not a sale, it's not a negotiated sale. And I'm not going to talk much about this at this presentation, but there are some tax benefits when your property is being condemned as compared to a sale, a private sale. But this is not a sale. So the red part is part of your property that's been taken for the new right of way. If you're connected to I-46 and you have frontage, the red part's what's being taken. The green part, light green part, is what the remainder is. So those are two very important components under Texas law and the Texas Supreme Court. Is how do we value what's being taken? How do we value the impacts of what is the damages to the remainder? And so we look at what is the value of what's being taken, what is the value of what the remainder is, and is the value decreased of the remainder because of what's being taken on the front end. It's also important for each landowner to know what is their highest and best use of this property. And that's a technical term from an appraisal standpoint. What is the highest and best use? You may live on a particular property that's on 46, but with all the commercial development that is happening from 46 going to Seguin, if there's no deed restrictions or it's not an HOA or POA, homeowners association or property owners association that restricts commercial use, the highest and best use of the property may be for commercial use. So instead of valuing that land and what's being taken from a residential standpoint, it may be higher value per square foot for commercial use. So what's it being used for now, but what's its highest and best use? And at Braun Gresham, we look very closely at that to make sure that you're maximizing the value of the land of what's being taken. And we also look at all other sorts of issues because I have clients that have lost a water well that has been in the part taken. Well, how do you restore their access to water if they don't have public water that's available to connect into and they have to re-drill another well? Are they going to get the same amount of water? Are they going to get less water? Is it going to be a dry hole? Are there regulations that limit the amount of water that they can access if they re-drill a new well? Also, there's septic systems that may be impacted that had to be taken out. And you're going to have to put in a new septic system, for example. What is the county's view on that? Because more and more regulation is happening related to water and wastewater and these sort of issues. Do you have a building on the part taken that's going to be taken? Do you have a building that is partly on the taking, on what's being taken, partly on the remainder? So they're taking half of the building. Does that mean the whole building is taken out? If it's a red iron, maybe you could say part of it, maybe not. But if it's on the remainder and it is 10 feet from the new right of way and you have lots of traffic, is that building or home being damaged as a result of being so close now to the congestion where somebody could go off the highway and run into their home? What are the safety issues that could happen? So all of these are impacts to the landowner that need to be addressed and see if there's compensation related to those impacts or a diminution in value of what's on the remainder as a result of that. So Texas law basically, from a broad standpoint, says, well, let's look at the total compensation. What is the value of the property before what's being taken? And what's the value afterwards? That difference between those two numbers is your general idea of adequate compensation. You had a very valuable piece of property before, now it's lost value. You've lost some other, the type of infrastructure that we've talked about. So how much should you be compensated? And again, just because you're being paid for what's being taken does not mean that there's an impact to the rest of the property. And that is a lot of times where a big part of the dispute is the whole property that's left, that you have left, may be so small, for example, that you can't develop it anymore, where you could develop it before. So the value of what's being left, or what that remainder portion is, maybe for what we call an assemblage tract for the next door neighbor to buy to expand their footprint. We look at all these sort of things and advise our clients on what is the best thing to do. And we will also, of course, try to maximize the amount of compensation because in essence, that's what you get under the Texas Constitution and US Constitution is compensation related to taking a private property for public use. Let me give you a real life example from a couple of years ago when 281 was being expanded from 1604 going north, and a lot of the lights were changed. So if any of you drove in that area when you had all those lights there, it just took forever to get into San Antonio from Blanco, for example. And now it is a thoroughfare. They've taken out all the lights on the thoroughfare, put the access roads in, and you can get into San Antonio quite easily. Well, that came at the sacrifice of businesses and other landowners that were impacted by that expansion. This was a commercial piece of property with a commercial business. And this is how we break it down from a landowner perspective to come up with what we think the compensation should be for this particular landowner. So you take a look at what is just the value of the land. Yeah, roughly $2.87 million. That's just the land value at the time. What are the improvements for the building that was on there that was for commercial use? Well, essentially 1.87 million. You add that, what is the whole property value, like I said before, the taking at 4.74 million? That's what the value was before TxDOT took out the building and impacted the property, leaving him very little property left on the remainder. And the improvements we zeroed out. So even though they only take half of the building, we demolished the whole building. What was the value of the whole building? Well, there's nothing left. So you should get paid for the whole building being taken out. And we were able to negotiate with TxDOT taking out the rest of the building, not just half of it, from various reasons, safety being one of those components. And then you look at what's left of the whole property after the taking. And so you subtract that out, and then you add in the TxDOT needed a temporary construction easement in order to do some staging. And so it was still on my client's property, but they needed to pay something so they could use that property for this construction easement. So from the landowner perspective, our damages were a little over $3.6 million. That's what we decided was adequate compensation. Well, TxDOT says no, it's only 2.4. So you can see there's additional compensation of over $1.2 million that we believe the landowner was entitled to versus what TxDOT believed the adequate compensation. So that's a significant delta or difference between those particular numbers, that if the landowner just took the 2.4, they were going to leave lots on the table without understanding, having some experts and having legal representation, how they could get what they really are entitled to receive in this particular project. We did have to go to a hearing. That's called a special commissioner's hearing, and we're going to talk through that particular process as well. And before I move in there, any questions, Brittany? Any comments from anybody? And if not, let's move into the fourth part of this is what is this condemnation process? What can I expect? This is where it gets a little emotional for a lot of people, a little confusing, a little complex on the timing, and how do you get through this condemnation process? Well, first of all, there are essentially four phases that I like to talk about. And the first phase is, well, I get a call or a letter from a right-of-way agent. We call them landmen. They're in charge of the acquisition. They want to meet you on the property, possibly. They may send you a letter saying we want a survey. And once you get the information of what's being taken, then it's time to start negotiating compensation or the terms. And we're going to go through each one of these phases in a little bit more detail. And then what is the purpose of the special commissioners hearing that I just talked about? And then what happens if I don't like what the special commissioners award, or what happens if TxDOT thinks it's too much? You go into that phase 4, and we'll talk a little bit about that. First of all, how do you set yourself up for successful negotiations? Now, this is Mr. DeValier, which is a landowner in Houston whose property was flooded as a result of I-10 expansion. And he's now before the United States Supreme Court on this Fifth Amendment issue that I was talking about. The Institute of Justice has provided this photo and have worked with him in the representation before the U.S. Supreme Court, which has been very beneficial to him. So this case for this Texas landowner rancher, he runs cattle and he's had lots of his property just flooded, and they have sued TxDOT directly in federal court, and TxDOT is challenging that. So it's going to be a very important case that we will monitor as the U.S. Supreme Court makes that decision of what are the landowner rights. But when you're trying to negotiate and be successful, I always have my clients, let's take a real close look at the property. As we talked about water wells, wastewater systems, buildings, how much is being taken? Is it an easement or is it a TxDOT taking? So they're going to own it in fee. I always have my clients talk to your neighbors, find out what they're being told so that everybody is on the same page as what's kind of the information out there. Because if you don't talk to your neighbors, there may be a lot of disinformation out there. It's time to start thinking, well, do I need an attorney, or I'm happy with the amount of compensation that they're offering me? Do I need to have an appraiser that's going to come in and determine what is the highest and best use of the property? Do I need a land planner? I have a client right now who has a coffee shop that is a drive-through, primarily with large trucks and trailers. They come in on one side or the other, grab a cup of coffee, and they have right to access in, access out. It's just a great business. They're losing some of their access rights as a result of the road expansion. And essentially, our land planner has looked at that and said that business is wiped out. There's no way you can utilize that business for that use now. It's going to have to completely be changed, which is going to impact their livelihood and the way they make a living. Sometimes you may have to look at a civil engineer to do some redesign work, maybe work with the cities or counties as far as redevelopment. And then a building estimator, if I'm losing a building, what is the value of that building from its appreciated standpoint? What would it cost me to rebuild that building on the remainder portion of the property? So all of these things are things that need to be thought about. If you set up, when you set up a consultation with me, we can look at your specific property, see what those impacts are, and see how we can help you, and you could anticipate whether any of these experts could be needed other than legal representation. So we go back to the 4 phases. As I mentioned, the first phase is a representative from the condemning authority. A lot of times TxDOT uses engineering firms that contact landowners and want to do the survey. They are absolutely entitled to do a survey because they need to have a very particular plat about what is being taken. But TxDOT is right now sending forms to landowners on SH46. It is asking them to sign a blanket right of entry that we can come on anytime we want without limitations, anywhere on your property, without limitations of scope or time. And while TxDOT has the right to survey, I negotiate a right of entry, which limits the time and scope. So it may be for 3 months, it may be for 6 months. If they don't finish, then they have to come back and say, we need more time. Now, you're not going to get paid for that right of entry, but it does protect you as the landowner. So you know when they're going to be on, how often they're going to be on. And if you have 100 acres and they only need access to 10 acres, then give them access to the 10 acres so they can do some studies, maybe some boring, maybe to some archaeological and environmental studies to learn the impact. But they shouldn't have access to the rest of the property because that's just unnecessary. But it is a time to be cooperative as far as that, because if you just say no, go away, they can go to court and get an injunction to force you to allow them to get on the property. Generally, the landmen or right-of-way agents will work very hard, but then it goes to their attorneys, and then the attorneys will say, listen, we're going to go ahead and file a lawsuit against you and get this injunction. So it's better to negotiate a right of entry than it is to just say no and they get a court injunction. Then that way they get to do essentially whatever they want to do under whatever time period. So that's an important part of the very beginning of the process. And then at some point in time, you'll get a offer, and that's called the initial offer. Then after that, you get a final offer. What's really frustrating for clients of ours and landowners in general is they'll get this 30-day initial offer. And it says 30 days because you have 30 days under the Texas Property Code to respond. They have to give you 30 days. But when you see that, and if it says you only have 30 days to respond, it could be very intimidating. But that comes from the property code. And you usually will get a landowner bill of rights from the Attorney General's office explaining a little bit about the process. We have a 2-page explanatory 2 pages that really helps people walk through the process because it is complicated. And even though we talk about it, when you get this letter, it can be impacting. And then you see what they're offering you on the initial offer, and it's generally low. I think there's more money and more terms that maybe have been missed that needs to be discussed. But they also, by law, under the Texas Property Code, then after the 30 days has expired, they have to give you a final offer and give you 15 days. That's when a lot of people go, oh my goodness, what's going to happen now? I only have 14 days to accept or deny. And some people feel pressure. A lot of people feel pressure to go ahead and either accept the 14-day or the 30-day. Now, TxDOT generally, as a general rule, when they send out their initial offer, there will be an appraisal attached to that. And then the 14-day written offer, which is the final offer, is generally the same amount as the initial offer. An appraisal is required by law. So TxDOT does during this process has to hire an appraiser to give you an appraisal of what that appraisal deems is adequate compensation. Now, on occasion, I agree with that appraiser. On more often than not, I disagree because they may have looked at the property as residential use. I think it's commercial use. So right there, you could have a difference between $2 a square foot and $10 a square foot of what's being taken, for example. Sometimes they miss the fact that there's a water well that's going to be taken out, or septic system that's going to be damaged, or very expensive fencing that is going to have to be replaced. All those things need to be looked at as we look closely as what is that compensation they're offering, and what's the value, and how do they come up with that value of what's being offered. And then you got to look at access issues, for example. If am I going to still have access to that property? Can I request a driveway cut in a different location so that I have access to the property? How is it going to impact if I have a business parking? Am I going to have reduced number of parking? And is that going to impact the value of my business because people are not going to park because they don't have any parking left? What's the impact of that? Do I have two drive-throughs and now I'm losing one? Or do I have a drive-through that I have two-way traffic on the one side in order to get to that drive-through, and now I'm losing that if it's a business? So all these things need to be thought about, and then the impact to the rest of the property, the remainder, as we talked about. What can I use that property afterwards? A lot of times, and this gets into some real technical issues, but at least I want you to know the term. I may have a property that I'm using that's what's called non-conforming because I've been grandfathered in on some sort of restriction. But once the property is changed, you may have to come into conformance with a particular zoning ordinance or something of that nature because the use of the property has been changed. But we also have situations where you can negotiate a better entitlement. A new driveway, for example, could be an entitlement that would add value to the property as a result. So that's a non-monetary item that still could add value to the property. So are those possible even to receive those sort of entitlements? Then after the 30 days is expired, after the 14 days is expired, you receive the appraisal as required by law. What next? Well, what next if you still haven't resolved and settled on compensation and these other issues we've talked about? Then a lawsuit's filed. It's a petition and condemnation. It is required in order for the condemning authority to go ahead and move forward with what we call getting the right to construct or right to possess the property. And here's how this works, is that TxDOT, for example, will file a petition and condemnation, and then the court in the county where that petition is filed, that judge will appoint 3 landowners in the county. So if it's in Guadalupe County, it'll be in Guadalupe County. If it's in Comal County, it'll be in Comal County. And these are 3 unbiased landowners who actually own property but are residents. So they can't live in California and just own an investment property. They actually have to be residents of the county. What their job is after their appointment is to hear testimony and award compensation. So, for example, TxDOT would testify from their appraisal that you're entitled to $1,000. Our appraiser may say $5,000, and so the commissioners have to decide somewhere between the 1,000 and 5,000, and that's their job. Now, once that award is made and deposited into the registry of the court, the condemning authority has the right to go ahead and start construction, even though the lawsuit's not been resolved, you haven't settled on the total amount of compensation. And if the award is more than TxDOT thinks is adequate, they could object to that award. And if the landowner thinks it's not enough, the landowner can object to that award. But if this money is deposited in the registry of the court, they can go ahead and start condemning, I'm not condemning, excuse me, they can go ahead and start construction, doing this condemnation process. And you can't stop that. You still own the property, for example, but they can go ahead and start the infrastructure. So a lot of times, depending on the timing, TxDOT may have a real hard push to have these special commissioners hearing and put the landowner in a really tight position from a timeline standpoint, because they want to go ahead and get this right to possess or right to construct, because they need to get this construction project out for bidding. It's called letting. And if they don't know when they could start construction, a contractor is not going to put a bid on it because time and materials change on a regular basis. And so they're going to know if I can start construction the first of the month, then I need to bid that for the first of the month, not an unknown period of time in the future. So from a practical standpoint, this possession has to be obtained so that contractors can put out bids to start the construction of this infrastructure. Now, as I mentioned, if either side does not like the award, then either side could object or appeal and object to this particular award of compensation. And then it just goes to the trial level. So before this, it's called an administrative part of the process. And now you're just flat out in the courts systems. Either side could pay a jury fee and have a jury trial. And just like the special commissioners, a jury decides compensation. And if you went to a trial, then you would have a jury in front of there listening to testimony from both sides, decide compensation. The difficulty at the trial level is that depositions could be taken. So you as the landowner could be deposed. If you have an appraiser as an expert, that appraiser could be deposed. And of course, all the experts charge an hourly fee for their time, and usually they charge more by the hour when they're in litigation at the trial level than they do at the special commissioner stage. And so this can get fairly expensive. And if you don't have a large enough taking and compensation claim, it may not be worth going to this level and you want to settle before this. But even if you do object to the award, 90% of the cases are resolved as a general rule without going to a jury trial. Most courts require mediation, which is not arbitration. It's non-binding mediation, and most likely will be required for the parties to try to come up with a resolution. So that's the fourth phase. Very few cases get to the point where you have to actually go to a jury trial. So that's the general idea of this project, the condemnation process. And again, whether it's SH46 or whatever condemnation process, if you're being impacted, these are the same rules, regulations, laws that apply on any particular project. But as I mentioned, every landowner has a different situation. Every landowner needs to be considered individually, even though if I have a group of neighbors on a particular project, the impacts are very unique to that particular property. And Brittany, you can speak to this a little bit more when I turn this back over to here, but we love to provide consultations to our potential clients about your particular needs, and we take on cases that we really believe we can help people in the landowner through this process. We generally work on a contingency fee. And if you talk to other condemnation lawyers, that's a standard. Our fee is often lower. For example, if you're offered $1,000, we get you $5,000. You're going to get that $1,000, and our job is to get you more than 1,000. If we get you 5,000, then we get a percentage of the delta, or that $4,000 that we got on top of that. Plus, we negotiate all these other compensable items that we talked about, or entitlements, or other issues. On this project of SH46 and any other particular project, if you call us, we're a consultation, and you want us to provide you a particular map of how your property is being impacted, how you, the landowner, is being impacted, we're happy to provide an individualized map with your particular situation, so we can discuss it more closely rather than just a generalization of this project. So again, my name is Patrick Resnick. I am a Texan. I'm born in Texas, grew up in Texas on farms and ranches, and work all over all over the state. Love what I do, and I'm very passionate about helping out landowners. This is our general phone number. This is my email address. You can email me or call, schedule an appointment. Go to our website. I think there's an information page. You can send an email for further information. And Brittany, I'm going to pause there, see if there's any questions, any comments that anybody has, and then I'll turn it back over to you to wrap up, if that's okay.
Yeah. So we didn't have any questions right off the bat, but we did want to reiterate that you can contact us via the phone number that's on the screen. We also have Patrick's email or our general info at braunandgresham.com. And we do have a SH46 page on our website that we will continue to update as updates come to us so that we keep you informed. And like Patrick mentioned, we do want to be able to provide a consultation to you all and try to understand your property a little bit more, and also provide an individual map of where this project is going based off of your property. So please contact us, either option, to be able to get more information.
Thank you, Brittany. Let me also state that we do have clients on this SH46 project. So even though our office is based in Dripping Springs, we have a statewide practice. We don't charge for travel or meals or those sort of expenses. So you don't have to worry. I'm going to come out. I'll be out on the SH46 properties on a regular basis. And so if you want me to swing by and meet you on your property, in addition to a consultation, happy to arrange that, because I have to see the property in order to really assess for my clients the impacts, other than just looking at the map. So want to emphasize that. And also, Brittany, if you can talk about our landowner alert system, or LAS as we call it.
Yeah, so we provide a monthly newsletter with important information that is just going on. Like Patrick had mentioned, other cases that we follow, or other road project condemnation projects as well. And it kind of gives more information on our vast practice areas that we have here at Braun Gresham. So you can go to the link that's provided on the screen, or if you're on a desktop right now, you can use your phone and scan the QR code to sign up to get more information whenever we have that out monthly. Or we can also email you more on this particular project. We did have one quick question, Patrick, that just came in, if you have time to answer. This person said, would you recommend the landowner get their own independent appraisal before hearing TxDOT's appraisal?
I don't. I recommend that we first see what TxDOT appraisal is, and then we analyze that, and to see if it's a good appraisal, if we have any issues with it. At that point in time, I can assess it, say, no, listen, they have really missed the boat, so to speak, on the TxDOT appraisal. Now let's contact our own appraisal. And I want to emphasize that condemnation appraisals are not like a bank appraisal. They're not like a refinance or a bank loan or something like that. Because of the complexity of the impacts to the taking and the remainder, these are very specialized appraisals, and there's not a lot of people who know how to do that and how to do that effectively. They are not they're not cheap, so it's going to cost you, you can't just get an appraisal for $500, $1,000. It's going to cost more than that depending on it. And so we want to look at how much additional compensation is there to make sure that the value added of getting this appraisal is there. So once you get that 30-day offer and that TxDOT appraisal, then we'll look at it very, very closely. And then at that point in time, make a recommendation as far as hiring your own appraiser for an appraisal, because you shouldn't go to that expense unless it's absolutely necessary.
Wonderful. Well, again, we just wanted to thank you all for attending. And again, if we reiterate what we said in the beginning, we will be sending this recording out to you via email. And so you can revert back to it and look at any of the links that we provided to be able to get in contact with us or sign up for our landowner alert system newsletter.
I want to thank everybody for attending. Thank you for your attention. And as promised, it's a 5 till or so. So we respect your time and appreciate you attending. Brittany, we have another one at 6 p.m. today.
Yes,
All right. Is it the same link?
it'll be a different link. Yes.
Okay. If you're interested in attending again at 6, it'll be a very similar presentation. Or if you have somebody that you recommend this to, just let us know and we'll make sure they get that information.